On the call of the roll. Member Nee.
Here.
Nee present. Member Grant.
Here.
Grant present. Chair Washburn.
Present.
Washburn present. We have a quorum.
Mr. Young, would you call the next item on the agenda, please?
Item number 2, adoption of the September 17, 2013 regular meeting minutes.
Madam Chair.
Member Nee?
Move to adopt the minutes with the suggested edits that I have submitted.
Member Grant?
Second.
I've had a chance to look over the edits, and they're thorough and excellent. When I was reading this, I had one substantive question about it in item number 4, public comment, about Ray Hart's, Ray Hart said the openness of the Library Commission is void compared to other commissions. I'm not sure what that means. I mean, if it's a paraphrase of, if it's what he said, then it's what he said, but I'm not sure. I guess he was saying that.
He was expressing displeasure with the way that the Library Commission, he's saying that the openness, the fair openness and transparency of the Library Commission compared to other, I think that's what he's saying, compared to other commissions was void, like it doesn't count. And if I recall correctly, the other speaker, is that big presentation?
Mm-hmm. Yeah, the PowerPoint.
PowerPoint presentation. So I remember, I think they were just talking about the Library Commission and the concerns they had with that. I just think he was making a statement.
Right, that was my recollection. I was just wondering if there was a way to word that so that it was more clear about. Ray Hart stated that compared to other commissions, the Library Commission is not open and transparent. That might be. Does that make sense, Member Nee?
Yes.
Yeah, I think that would be clearer. So, is there any public comment on the minutes from the September meeting? Okay. Seeing none. Would you call the roll on the...
On the motion to approve the minutes as amended. Member Nee?
Aye.
Nee, aye. Member Grant?
Aye.
Grant, aye. Chair Washburn?
Aye.
Washburn, aye. The motion passes unanimously.
Mr. Young, would you call the next item on the agenda, please?
Item number 3, file number 13024, hearing on the status of the order of determination of Mika Ringel against the Planning Department for allegedly failing to provide requested records associated with the proposed development of 480 Potrero Avenue.
Okay. Are both parties here? No. Well, let's go ahead. Mr. Ringel, would you bring us up to date on the status of this order of determination? You have 5 minutes.
Thank you. I'm not sure if this is by design, that they're not here. I think it might be easier for them not to have to explain. If you'll recall, Don Lewis and Ben Fu, the two planners who were essentially responsible for me bringing this complaint, didn't show up last time either. Instead, Lulu Wong showed, she's the office administrator, she's the one who hands you the files. When Lulu says, as she had, the department's given you everything that there is, to Lulu, that's probably correct. If the planners say, I have everything, then I have everything. You know, she doesn't have the, anyways. From the order of determination, Order 1, Operations and IS Administrator, Planning Department Respondent, presented the Planning Department's defense, presenting the complete case file to the task force on a compact disc. I would love to have the complete case file on a compact disc. It takes me a whole minute to scan each page at home. But no, I got the same emails that I had gotten before. 2 weeks later, I did receive an email stating I have a CD with more correspondence. Will Micah come to the planning department? And I came in the next day. It was Halloween. And it was interesting because while I was at the planning department in the lobby, they were having their Christmas party. And I could hear in the next room, there was somebody dressed up as red tape, bureaucracy. Which, I mean, would be a good costume, but that's all I'll say on that. So the CD contained nothing from Don Lewis. In the case file was this page, and it was my submittal. Don Lewis says, well, first I have to read it from backwards order. Lulu Huang, okay, help me out here. Since both of you expressed that you will not be going to the SOTF, please help me to answer the question. The main concern Micah had, he said the correspondence folder for 480 Petro is empty. Where are the files? Ben Fu says, I'm not sure if there's even a correspondence folder in the file, but all emails were placed in the iDrive, which is the shared network drive. Well, there definitely was a correspondence folder because I took a picture of it empty in the case files when I went to review it, because again, I'm looking for my family's emails that were submitted during the public comment period. And they were substantive emails. Substantive as far as the cover page of the negative declaration has the wrong district and supervisor. The project is in D10 Cohen, not D9 Campos. And when the negative declaration was amended in April, months later, it became obvious that they just disregarded all public comment that was submitted. So Don Lewis writes, all correspondence post-Sunshine request is in the file. We are not required to keep every non-substantive email in the file if a Sunshine request has not been filed. And that's not actually correct. Under the California Environmental Quality Act, California Code of Regulations, Title 14, Chapter 3, Article 13, Section 15208, preserving the administrative record for judicial review. Everything that is submitted, it's literally known as the kitchen sink, anything that they've come across, every draft document, everything is. And so I was thinking that with this order of determination, I would receive the bulk of the emails that I'm looking for. And I know I don't have to justify my request of why I need these, but if I could show you some of the things that I've uncovered in the case file. The negative declaration says there was a shadow study. This is the shadow fan. And there was a approval letter saying this project will not cast shadows on Franklin Square Park. After months and months and months of being told I had everything that there was, I get literally this many more files, including this many from 2002 that I had to pay $35 to get from Iron Mountain. But someone had access recently before me because files were traded from one case to another. But then files that had been sequestered on the 5th floor of the planning department, including a failed shadow study that shows the project will cast shadows on Franklin Square Park. And it's not just the failed shadow study done by the department, but it's the fact that a letter was sent. Dear Mr. Tabazo, if your project cannot be approved, I could stop her.
You can finish your thought, please. Yes.
And then there's, where is the graphics folder? Because the applications say no cars are there, that it's a vacant lot, 0 cars. When I finally get the graphics folder, it's full of cars. It's a parking lot. The fact that the CD I got on that date was nothing new, let alone I've been trying for a long time, because I would like to know where the cover-up is with these. So, someone knew there was, I mean, a lot of people knew, and there was a cover-up, and those aren't the only ones. 5 minutes, 5 minutes.
Okay, you'll have another opportunity, and we'll surely have some questions. Is there anyone here to offer facts and evidence in support of the complainant? Okay, I believe the respondents are here on the case with Mr. Rengel versus the Planning Department. So would somebody like to speak to? You have 5 minutes to bring us up to date on the order of determination that was issued on October 23rd.
Yeah, Don Lewis with Planning. Apologize being a little late here. The complainant is mainly asking for communications before the Sunshine complaint was filed, which would then be part of the admin record. He's looking for documents that would not be considered part of the admin record. Non-substantive emails do not belong in the admin record. So I'm not sure what else we can provide him. We provide him everything we've had for several months now. And I did the environmental review of the process, so I can speak to the environmental files. But all the communications that are required per CEQA, guideline section 15208, which he cited incorrectly, are in the files. So I'm here to answer any questions. But again, non-substantive emails before the Sunshine Task Force was filed do not belong in the admin record. And I believe he has an email from his mother that was asking for the environmental document. There was no comment on the environmental analysis. It was just a request to have the document sent to her, which we did do that. And also, the environmental document was issued October 2012. I think the Sunshine request was almost a year after that. So the case was pretty much, the environmental case was pretty much closed, but there was an appeal filed, which was taken to the Planning Commission. The appeal was denied. The environmental approval was upheld, and then Board of Supervisors also denied his appeal. And environmental review document is complete, found to be adequate. So I'm here to answer any questions. I'm not sure what else I can say.
Is there anyone else to offer facts and evidence in support of the respondent? Okay, the matters with our committee members. Member B.
Mr. Ringel, please. What documents do you believe remain missing, and what, considering particularly what we've been told by the respondent, what they're telling you is they've given you all the documents they have that are relevant to the matter at hand.
Sure.
What documents do you believe are missing, and what reason do you have to believe that the documents exist?
Well, I'd like to say that I was right about the shadows, and I knew it because it was actually written at the bottom of a receipt that someone had paid. This is willful. This is not an accident. This was not, they sequestered it and they lost it. This was people hiding files. Even now, they do not want to hand over the correspondence because I would like to know the communications between them and the developers, between them and their colleagues. I was told that I had every file that there was. Mr. Wong was able to find 5 historical documents. But how about the whole box of 2002 case files that show the picture of the former structure, that show the geotechnical report that was recent, that show this is willful. To her, not willful. To Don Lewis and Ben Fu, willful. They knew that there was a U case file. They knew there was an exclamation point case file. They knew there was, the traffic case file, the shadow case file, the preliminary project assessment case file, where all the pictures are labeled incorrectly, saying which way is north and which way is south. And what am I looking for now? I have no idea who else commented during the public comment period. And I've been asking for the communications. They're not privileged. They existed. If they've deleted them, then they can be resurrected from the servers. It would have been a lot easier then when they were fresh and on their files, but there's not a question if the department has not been forthcoming and if there's reasons for them to be not forthcoming. And as far as the Board of Supervisors upholding the project, they did. One supervisor, our district supervisor, voted to affirm the project, and they all concurred with her. It was a little different than everyone individually voting. And I believe the neighborhood groups filing judicial review of the project, unfortunately, that's what it comes to, because, I mean, there's a lot of issues, and so the adequacy of the document really isn't what we're talking about here. It is, why were there hidden shadow studies? Why did he write a document saying there's only one shadow case? I mean, this is substantive when there's shadows in violation of Prop K. So what do I think is existing now? I think there's, well, first of all, I'd like to see my emails from them. And they were not just asking for the environmental document. Actually, we already had the environmental document. So, anyways, if that answered your question.
Graham, do you have anything?
Well, Mika, I just want to follow up with Member Nee, just because, what we can do here is provide you with your documentation that you're requesting, and that's public, privilege for you to get it. But I'm still confused as to what it is exactly.
Now?
What do you need? What is it that they have that you're saying that they have that you have not received, documentation-wise? I understand there are a lot of issues, but
Yeah.
that kind of, we got to take that out the
At
right now?
this point would be, I've received only emails from them since the Sunshine Ordinance was filed. I don't think people file a Sunshine Ordinance to receive documents in the future. They tend to have needed them in the past. And so I haven't received any emails since I filed the Sunshine Ordinance back in March or April or May. I don't know when it was. But, and I doubt I've received them all going forward. Oh, I'm sorry, I also brought something for you that I thought was interesting if I have it. It's not from these planners. I may have left it on my chair. Can I have them? Okay, I'm sorry. I do have them. Here they are. It's on the same one page. This isn't from these planners. This is from another planner, from another case file, to the new Assistant Zoning Administrator. The department has a practice of cleaning their correspondence when they get them. I mean, when they deliver them out to the public. So I think these were cleaned so much that at least, I mean, I get a couple hundred for the couple cases that I've requested them for on a PDF in Adobe format that I can search through, and it's like there's several hundred emails. Some are important, some aren't. This was buried in one for another case. Yet for this project, I receive about a dozen only that are in the case files, and I don't understand why. Why aren't there a couple hundred from, and most of them are from me, yet they've communicated with a lot of other people about the project. So I don't, and why do I want them now? I mean,
That doesn't matter. Mr. Ringel, yes, first of all, you don't have to explain to us, you don't have to explain to planning why you want any documents. And we presume, the Sunshine Ordinance presumes that virtually every piece of paper, every electronic file in the city is a public record, except in very limited circumstances, which if you're citing those, you have to be very explicit about the law that says that those are not disclosable. So, that providing that context, when you originally, just to refresh my memory, what did you originally ask for?
I went in to go see the case files, and Don Lewis had his case files ready. He said they were available. I went in the next day. Ben Fu didn't respond for 10 days, and so I sent an email saying second request, and he said, if you're making this request under the Sunshine Ordinance, contact Lulu Wong, otherwise I'll have my case files for you, after waiting for 10 days. So I went in, viewed his case files, and between the two, my emails weren't there. There were documents cited in the negative declaration that weren't there. There were supposed to be, if you look at the rules of what the record should be, there should be a graphics folder, for instance. That wasn't there. And inside that graphics folder should have been a picture of the site with full of cars, which is what it was when I got it months later. There's no doubt that as someone who volunteered for the neighborhood organization to do the case file research, it's turned into, this has really affected our defense of the project and almost kind of created this whole other side issue of how it was reviewed, because a lot of it had to do at the end with, I think, we're creating problems and, we're bringing it to the Sunshine Ordinance and we're doing this and that, and I never had any idea that that the two would be related. But even if from the date I got the notice of determination, had the department complied, I could have had time before the Board of Appeals hearing, which is tomorrow. And I'm happy that this hearing is now, but it's just like the last one was after the Planning Commission had already approved the project, and that was months later, and I was a week away from the Board of Supervisors hearing. Now tomorrow is the Board of Appeals hearing, and again, someone at the department, after getting the notice of determination, made a decision, we don't have to give them anything. No, because we don't want them to see it. And the reason why is because there's something there. And I was trying to review as much as I could about the Sunshine Ordinance and the Ethics Commission and how the two are related. It is willful.
Okay. Mr. Ringel, so we determined, when we heard this case before the full task force, we determined that, in our opinion, there were some outstanding correspondence, emails, documents. And so this order of determination, states to the planning department, you must, within 5 days of receiving this, give these records to Mr. Rangel. So what happened?
I got a CD. I went and got the CD. I received some emails from Ben Fu since I had received the previous emails from Ben Fu, but nothing prior to when I had asked for. I had said at the hearing that none of the links, whereas the developer said, here's updated graphics, but none of them were attached. So that was pretty much the same. I mean, I received a couple more emails, but nothing new. And there was a folder named Don Lewis, and it was empty. And so someone had actually pulled it off the iDrive. I've received 4 CDs. I meant to bring them with me. I had them packed up, but they didn't make my bag. But I'd be happy to share them with you. I received a little bit more from Ben Fu, but actually nothing from Don Lewis. And
So now, you've received emails that were sent subsequent to your initial request.
yeah, it's.
But what about the emails that you were seeking back in the spring? Did you receive anything from that period of time?
No. Don Lewis does not think he has to. He's actually.
Well, let's ask him. He's right here. Okay.
You have it in writing.
All right.
So before you go,
Yeah.
so you have received emails from what date?
Well, there were, in one case file, there were 10 of them, but not mine or my mother's, which was strange. So that's kind of what led me on this,
Okay, so what date was that after you filed your?
I went in to first review the department's files in the middle of March.
Okay.
And I've received some since. Every CD kind of has different files and different,
So March 2013.
yes, March 2013.
So that's when the correspondence started for you.
That's,
When you-
March 2013 was when I found the first 10 in the folder. I didn't receive a CD or anything others. I asked, where is Ben Fu's correspondence folder? Why doesn't he have one? Because I was trying to, maybe my email went there. I didn't know where.
Got it.
They segregate them as by design at the planning department.
Got it. Okay.
And so, yeah.
All right, thank you.
Mr. Lewis. Okay, so I'm trying to figure out what exists or what existed, and whether or not Mr. Rengel has all of what he asked for, and if not, what is your basis for withholding information?
Well, I'm not sure what he's looking for. I've had probably maybe 50 emails with him back and forth. I don't know what he wants. Again, the environmental document was completed September 26, 2012. When we publish an environmental document, we put together the admin record, the administrative record, and the file in case is pretty much complete. Any emails of non-substance doesn't belong in the admin record. Emails that commented on the environmental document itself are in the admin record. So he's looking for emails between the project sponsor and I'm not sure what he's looking for, but any email of non-substance is not going to be part of the admin record. Now, after he filed the Sunshine request, everything was put in the file, and it's mainly all correspondence between Micah and myself and Micah and other of my colleagues. So I'm not sure what he's looking for.
Okay, you mentioned non-substantive email. So who makes the determination that it's non-substantive?
I make the determination based on our training with the city attorney. Emails, what not to include administrative, right? We had training from the city attorney last year, and she told us exactly what's not part of the admin record. Administrative drafts, draft notices, draft staff reports, draft technical reports, non-substantive communications, including emails. So if the one email that I know Mike is talking about is an email from his mother asking to receive the CEQA document. Okay, I put that on my list of all commenters on the environmental review. I have that, and I print that, and that's in the document. Of anyone who wants to receive the environmental document, that's in the file. I don't need to print that email saying that she wanted to receive it. There's been no argument that she has not received the environmental document. And again, the environmental review was adequate and complete, found by the Planning Commission and the Board of Supervisors. He's talked, so I don't want to talk about that, but again, we strongly disagree with anything that he's saying about communications, and we're not withholding any information from him. I don't know what the reason would be to do such a thing. So, any other questions?
Well, okay, Member Nee, maybe you can help me out here.
You said the withheld communications were draft, is that correct? And that the city attorney had advised you that those were
we didn't withhold them. They were. He was again. The environmental document and the admin record was pretty much finalized, and then a year later he files a Sunshine request, and he's asking for all this information that is not part of the admin record. So, we keep providing him information, all the information we have, but he's still looking for documents that just don't exist.
But under what statutory authority are you withholding them? Substantive or not, under what statutory authority?
Would I withhold documents?
Yeah.
Or not withhold documents? I mean, we implement CEQA, the California Environmental Quality Act, guideline section 15208. And that's what he says that we're not in compliance with, which is not accurate. So any email of substance is in the admin record. If it's non-substantive, it's not in the admin record because it's not required to be in the admin record.
But what do you mean by non-substantive, and who really is to make the determination on that?
Okay, so an example, an email from Micah's mother asking for the document. Can I please have the document? Okay, no problem. I put it on my list and I send her the document. That doesn't comment particularly on the CEQA analysis. I'm conducting environmental analysis. If there's no comment on the CEQA analysis or review, it's not substantive.
So you're saying that if the email sought is merely a matter of procedure rather than substance, then it's exempt from disclosure? Is that what you're telling us?
The only example I can provide is the one that he's claiming, and that's from his mother asking to be put on the list to receive documents.
And you're saying that that particular communication is exempt from disclosure?
Exactly. At this point, but if it was after the sunshine request, we would keep everything.
That's, with all due respect, that's not how the law works. Again, the presumption is the Sunshine Ordinance is our local ordinance along with the California Public Records Act that governs what is a public record and what isn't. And like I said before, virtually everything produced in this building or any city building, by a city department is a public record. It may not be what you might think of as an important or substantive public record, but nonetheless it's a public record. So email correspondence, just routine, what you might think of as just day-to-day inquiries from the public about things, that's a public record. Calendars kept by public officials that just list who came when, that's a public record. They're just very mundane stuff. Those are public records, and so they're disclosable. And even though all of that correspondence that happened prior to this report, which brought in a lot of information and was a lot of work, it didn't directly feed into it. It was nonetheless part of that whole project. And so, again, unless there's some specific law that prevents that information from being disclosed, and it's things like attorney-client privilege and information regarding some disciplinary action or medical information. It's very, very specific, and it's spelled out. And so routine email is not exempt from disclosure.
This one. Lonnie Turrell, Senior Environmental Planner with the Planning Department. We are taking our advice from the land use attorney, Kate Stacy, and there seems to be a lack of communication between this particular commission and the city attorney's office.
Could you be more specific?
When we receive training from the city attorney's office on what we are to keep and not to keep in our records, it appears to be not what you are saying.
Member Nee?
What we are saying, ma'am, is that absent certain specific, very narrowly defined guidelines or definitions, the default is all correspondence, emails, drafts, memoranda, everything, except in certain very narrowly defined circumstances, are disclosable. And when you withhold,
We're not withholding. We don't keep them. They're deleted. They're thrown out. They're no longer of any use, and they have no relevance to the project.
and they're not backed up before you delete them?
I really think that there needs to be some communication with the city attorney's office, because what they say and what you say are in direct conflict with each other.
How old are the records that were deleted?
I have no idea what was deleted. We do not keep non-relevant emails. If someone sends an email saying thanks, we don't keep that. If we have an administrative draft that is superseded by another document, we don't keep that. And we are doing this under the direct supervision and direction of the city attorney's office.
briefly reply to Nanny Churro?
Certainly. If you could address your remarks to us, because we're trying to understand what's involved here.
First of all, the email, again, was substantive. It was the infascia air of the negative declaration that on the cover page it says the wrong district and the wrong supervisor. In fact, I was emailing our neighborhood group about the Board of Appeals meeting, and somebody emailed me from the community saying, I'm confused. Is it in Campos or Cohen? Trying to figure out who to appeal to, for support for the... So this is wide-ranging. This is not... And so there was an email from my mother. That one should have been there. The significance of that email, and it wasn't asking for the document. We had the document. It was her saying, I'm concerned about the environmental effects. Because in the negative declaration, he says, nobody was concerned about the negative, because we saw the building be demolished illegally. And that's why it was a pit in the ground. It's difficult to explain the process, but there's more to it than that. But if we're to believe what Nanny Terrell is saying, this failed shadow study is not substantive, the fact that it was on the 5th floor, or the preliminary project assessment files, that those were not substantive. I mean, it goes beyond just the emails and the correspondence. There's no question. I mean, I said all along, I know for a fact that there's more in the custody of the planning department, yet even up until last week, Lulu Huang says he has everything that there is. We don't have anything else. We're not keeping anything. We don't willfully do that. And to her, that's probably true. But the reality is, it is proved, I mean, we have failed shadow studies. It's a big deal. So.
Member Name.
I think it might be instructive if we look under certain definitions. In section 67.20 of the Sunshine Ordinance, subparagraph B, public information shall mean the content of public records as defined in the California Public Records Act, Government Code section 6252, where provided in documentary form or in an oral communication. Now, section 6252 of the California Public Records Act, paragraph E, subparagraph E, public records includes any writing containing information relating to the conduct of the public's business, prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristics. As I see it, the information that was, the communications that were deleted should not have been.
I agree with you. I've been looking at section 6724, public information that must be disclosed. And, as we well know, there are just very narrow types of information that are exempt, and this type of information does not fall into any of these categories. Now, I know that correspondence, particularly if it is thought to not be substantive, however that judgment is made, may be deleted from the individual computers or in a more central location, but I understand that information is backed up in the city, and so these files undoubtedly exist somewhere or other. We've had cases like this before where it's very hard to obtain this information, but it exists. And if somebody wants the information, because it is a public record, it is disclosable. Member Nee.
Yes. I would also point to Ordinance section 67.29-7, particularly subparagraph A, The mayor and all department heads shall maintain and preserve in a professional and businesslike manner all documents and correspondence, including but not limited to letters, emails, drafts, memorandums, invoices, reports, and proposals, and shall disclose all such records in accordance with this ordinance. That says a lot.
Right. And it is true that city departments will often say that, well, our city attorney said that we didn't have to disclose this or it wasn't a public record. We also have a city attorney that works for us, and our city attorney drafted this order of determination, capturing our decision after the hearing, and this is what we determined. So I haven't heard anything to change my mind. Member Nee?
Mr. Lewis, please. You don't know if the emails in question were backed up before they were deleted or destroyed?
I have no idea.
Okay. Have you asked the Department of Technology to help you in any way to see if those records had been backed up or were somehow retrievable?
Lulu Wang from Planning Department. If the email received and he reads it, he deletes it, it will not be back up because it doesn't even stay in the system. The email is stay in the system at least overnight, and then the email is back up. And plus, because they changed the system, it's not Lotus Note anymore, so everything is in the cloud. If we were to like you say, search for, let's say, 480 Patrol, we need to send out the request to the DT department. We cannot do it ourselves anymore because the system changed. That's all I know.
Okay, so, excuse me, Lulu? Yes. Thank you. So you're saying that if the email was not deleted within, if it was in the system for overnight, it would have been backed up? So everything is backed up every day?
Every day, yes.
Okay. So, so there's a possibility that a lot of these emails exist, but you would have to ask the Department of Technology to retrieve the information for you.
Right.
Okay.
Some of them will not, you will not find it because it's never stay in the system.
Right, I understand that.
Right.
Did you put that request in? That's what we want to know. Like, did you guys put forth the effort and put that request in, even though it's changed now?
I did talk to the DT department, and they are looking into it because I remember the last conversation I had with the DT and my boss that they are going to request. How long would it take them to come back? We don't know because it's not governed by us. For example, let me tell you that let's say for the request for reserve a room, okay, very simple. We used to be able to make correction. Let's say room 480 is no longer be used. We put a request to have that room removed because it's changed into something else. It would take them 3 months to do it. We have to keep that thing in the system. People keep on asking because it's not under our jurisdiction anymore. So I did convey the request to the DT department, yes.
Okay. Members, do you have any more questions before we move forward? So I want to be clear. So there has been a request made to try to retrieve these emails in question. Okay, I understand that they're not part of the official record, and that's fine. But the fact is that if they exist, then they're disclosable.
Yes, but we do need to narrow it down to a period of time because they cannot just go blindly and say, okay, give me something for 80 per turtle. I don't know how far the record was kept, but we do need to narrow it down. Okay, please give me email from 2001 to now or something like that.
Okay.
So I need to still go back and talk to the DT department.
All right, okay. Okay, at this time, are there any more questions from members?
So have you had that question with Mika? Have you guys had that conversation about what he wanted specifically? And since you said you went back to the DT, I understand that some of the emails are going to be gone regardless. But have you had that's kind of what the order of determination was, that there was supposed to be this disc. And I apologize, I wasn't at that last meeting, but from what I understand, that there was a request made that a disc with all the correspondence. And he's saying that that disc, when he got it, was empty. Correspondence from Ben Lewis was empty. And is that right, Mika? That there were supposed to be emails from you to him that you were looking for? Yeah, come on. Is that, I just want to be
There's a
correct.
couple things, like it's not just the emails. I asked for, it got to the point where I asked for every file that they had in the custody. There were reasons for that. Some of them,
Every file that is about 480 Petrero.
yeah,
is what
because
you
I
asked
actually
for.
wanted the Word document or some other a PDF that was a real PDF and not a photocopy of the negative declaration that is of a photocopy, because you can't see any of the pictures. I mean, it's printed so poorly. I have it here with me if you'd like to see. And it's not like that on my copy. It's like that on every copy that was distributed and on the servers right now. We were talking really poorly. So I actually wanted them in other files. I mean, I wanted to review everything because there was enough wrong with this. And I mean, I wanted the attachments at least. When they're talking about something and then you don't get the attachments to them.
So is that what was in your, you just need to really narrow down
Well, from Don
what it
Lewis,
is.
I got nothing new. Essentially, there was his name on a folder, and that folder was empty on October 31st since the hearing.
So that's what they
Lulu
gave you
Wong
subsequently.
did speak with me because I went in to review another file, and she did speak with me about an admin doing it. I have the name of another case that was here last year, 2012 or something, and it had to do with a court discovery or something, and it was, could we maybe get the record cheaper by doing it through the Sunshine Ordinance or something instead of having to pay for an IT administrator 6 hours at $60 an hour or whatever it was going to be, and there was this tabulation of something. I mean, planning departments get sued a lot. You know, it happens in terms of development and land use and stuff, and so I don't believe what they're saying when they say this as far as... I mean, that's me.
Yeah, that's, and I mean,
Yeah,
he
sorry.
said, she said, that's fine. We just really want, what we can do for you guys is we want to know what is it that you
It's-
want and
at-
what
at
have
the
you
last
not
hearing-
gotten, and is it available?
At
And
the
if it's
la- at the
not
last
here,
hearing-
that's what we want to get to.
If I could have gotten the files, I would have been really pleased with the files and could have moved on and could have they could have been constructive. At this point, they'll be useful, but they're going to be useful now in a whole other realm of judicial review. And things are changing. At the last hearing, when things came to vote, Board Member Nee gave out 4 different things. One of them was willful. And at vote, although a majority of the board approved, Board Member Nee withheld his vote, and he said something along the lines of, I reserve my right, if this comes back to compliance or for further noncompliance, to reserve my right. I don't know what you meant by that, but that was how I had transcribed it. And at this point, they've messed up a lot of things. And now we're talking about, they hid failed shadow studies. This is, I mean, major. It's not just the correspondence. It's not, you have to believe that really I got maybe a dozen correspondence in the case file, nothing new. They can't find anything past when I asked for them. They didn't retain anything. Why? I mean, it doesn't sound right unless there's something to hide. And I believe there's something more.
Thank you.
Thank you.
All right, at this time,
Do you want to respond to that?
I just want to say that I work very hard to work with Micah, very hard. I offer many times. I said, please, let's say we messed up, okay? I apologize, I messed up. But can we start fresh? Tell me what you want and I go get it. Many times. And then I go get it, and that's all we have, whatever I can gather, and gave it to him. So if you think that we are withholding something from him, that is not a true statement. That's all I want to say.
Thank you.
Okay.
Okay, at this time, I'll ask the respondents for a formal 3-minute rebuttal. If you have anything additional you want to say, you have 3 minutes to respond.
There's a difference between your admin record and a sunshine request. The admin record was complete when we finalized the environmental document. Several months later, the sunshine request was filed. We don't have emails of non-substance in the record. We can't get those. I'm still not sure what Mike is talking about. He's asking for attachments from the neg deck. All those documents are in the file. There are plenty of documents in our file. Plenty of emails of substance in our file, but he's saying that none of these documents are available, which is inaccurate. I mean, we've been through so many hearings already, and the Planning Commission approved the project, and the Board of Supervisors approved the project, and he's still upset about the project. I have nothing else to say. I mean, I think we complied with the direction that we have been trained by the city attorney with the admin record, and we strongly believe it's complete and accurate per the guidelines and per the administrative code. Thank you.
Thank you. Mr. Ringo, you have 3 minutes for a rebuttal.
The public has a responsibility to participate in the planning department's review and approval of projects in their neighborhood. I've written Don Lewis using words from government code saying projects aren't supposed to, it's not, anyways, I can't quote it right now, but things aren't supposed to be done behind closed doors. We have a right to know how projects are approved. I would like to see the graphics as they're updated from the developer. I'd like to see the updated design plans as they come in. And I've made a lot of efforts. And this isn't how I set out to. Again, if I had seen my emails there, I wouldn't have known any better to see. I just would have assumed it was correct. It was only because of my emails weren't there did I start wondering what else is not there and what else is not there, and actually start reading it. And since then, I've read every document, and I probably know the case files better than they do. As far as Ben Fu last week said, I don't even know if there is a correspondence folder in the case file. Yeah, there should be. That's all I have to say. Oh, let me finish reading, sorry. Both the informational and environmental protection goals are thwarted when information is not released and the public's concerns are not addressed in a public process. The refusal to release correspondence, to sequester failed technical studies, and to omit relevant documents received during the public comment period. Planning has prejudiced the goals of the Planning Commission and the California Environmental Quality Act, and has tainted the adequacy of the environmental review. And it will ultimately now have to end up in judicial review because of that. Projects aren't supposed to be approved without when there are feasible alternatives, and so fundamentally and basically inadequate and conclusory in nature that meaningful public review and comment has been precluded essentially in all the hearings except for this one. So thank you.
Thank you. Okay, the matter is back with the task force, or with the committee, not the Yeah, there are actually 6 of us here, but no, 5 of us. Sorry, 5.
Mr. Ringel, please approach the microphone. You heard Ms. Wang tell us that she has gone to the Department of Technology to see if there's a way of finding the deleted documents. Would it be satisfactory to you if we continued this matter for a month and you got together with Ms. Wang and the other ladies and gentlemen here, and see if you can come to an agreement as to what you can get, what you can't get, what specifically you want. Would that additional month's delay cause you a problem?
Yeah, we're actually filing a writ of mandate on Thursday,
Okay, thank you.
so I don't have that option.
Thank you.
One other thing. Sure. They weren't here last hearing. It's almost like we are now redoing a lot of this hearing again, and I'd like to point that out, that they really were the ones who should have been here last time, and if anything, it's further causing the delay that I now can't, actually. I have the last administrative hearing at the Board of Appeals tomorrow night, so I can't. Thank you.
So to be accurate, Ms. Wang was here before, but, right, before the full task force, right. At this point, I'd like to take public comment on this matter.
Hi, David Pilpel. I'm a member of the task force. I was not present for the hearing on this matter. I heard much of the Victor? I heard some of the testimony. I am aware of the project, but I don't have a strong view on it. I am fairly familiar with the planning department and its procedures, and I wanted to offer some comment that may be helpful to getting out of this. I think, in part, we have three different areas of law to examine here. We've got the Sunshine Ordinance and the Public Records Act that we're all very familiar with, that defines records, and we're interested in disclosure of records that are public to a requester. The planner, who I'm aware of but have not met, Mr. Lewis, referred to the administrative record that's a concept in CEQA, 21167.8.9, somewhere in there, and the relevant regulations about what constitutes an administrative record in a California Environmental Quality Act matter. And it sounds like this is headed towards litigation, so that's relevant for that particular circumstance. There's also the concept in Administrative Code Section 8.3 about the definition of a record, such that ephemeral records that have no legal significance or consequence need not be retained by the department. To the extent that records are retained by the department, they're supposed to be organized in a business-like fashion. They're supposed to be available for public disclosure. So I think we've got sort of three different things going on, and I heard a bit of confusion about what's a public record request versus what's in the administrative record for a CEQA proceeding. In terms of where we go from here, it sounds to me, and I did not see the original request from Mr. Rinkle, right? How do you pronounce it? Rinkle? Something like that, from Micah, for the original records, but I did see in the packet that he was looking for all documents, in addition to any emails and any other electronic forms of data held in the custody of the planning department, re 480 Potrero 2011.0430 U X E exclamation point, etc. So all of the various case files that the planning department might have relative to 480 Potrero, relative to that particular case number, which from my experience would likely include an E file, which is the environmental documents, and possibly a C or a U or some other type of file for the entitlement portion of the proceeding. So to the extent that those documents, and including the electronic data that haven't been produced, it seems to me like the order of the task force at the meeting I wasn't at was that those documents and data be produced and made available, and it seems like a month delay to encourage the parties to meet and resolve what was being sought, what was provided, what's still out there would be useful. I'm happy to provide anything else that would be helpful here. Again, I think there's this misunderstanding that could be clarified about public records versus the administrative record in a CEQA proceeding, both of which I'm fairly familiar with. Fair? Thank you.
Members? I'm just going to say, I know that Mika says he has something he needs this for tomorrow, but I am in agreement with you because I'm still unclear of exactly what he wants, what he has not gotten. And I'm more apt when the Lulu has acknowledged that she's willing to help, and there is that side of it, to not jump to conclusions and make a judgment, make a ruling or anything like that without giving the opportunity. The Department of Technology, as you have indicated, can be a little bit not problematic, but trying to get that information. It seems that it takes time, and so I just feel I agree with Member Nee in that a continuance is necessary, because I think if you've changed your mind, then I take that back. But I think,
Chair, with all due respect, Member Grant, I never said I thought a continuance was necessary. I asked the complainant if a continuance would cause him any difficulty, and his response was yes.
okay, so with that, I still think that a continuance is fair. So that is kind of where I'm going, because I feel that with both parties, I think that there's been indication that there was an effort to try to meet the concerns of the complainant. I don't know everything that was going on from the last meeting, but that's kind of where I am right now.
Madam Chair,
Member Nee?
even, it's unfortunate that even if we do move today to refer this back to the task force, it doesn't satisfy the complainant. We issued an order of determination. That order of determination set a 5-day deadline. The complainant is still not satisfied. And given that in the matter itself of 480 Potrero, they're right up against a timeline of sorts that's going to be well past by the time this reaches the task force in 2 weeks. It's unfortunate. I am leaning toward referring this back to the task force. There has been failure to comply with the order of determination, and there also has been an obvious failure of the planning department to keep correspondence and maintain correspondence and records as prescribed in 69.29.7. I'm inclined to refer this back to the task force with a recommendation for sending it along to ethics.
Okay, well, I'd like to hear from Mr.
Members of the board, Ben Fu, I apologize for interrupting. In terms of the emails, I believe Lulu is working on that with DT, so hopefully there'll be some resolution. But what we'd like to get some clarification on is exactly what sort of documents are still outstanding, because we have provided documents relating to case file K, which is a shadow study, which is how Mr. Ringo obtained the map. We have provided the case file for the case U, which is the preliminary project assessment. We have provided a case file for the X, which is large project authorization, which is the entitlement for the project. We have provided a case file for the E, which is Mr. Lewis's case file for environmental review. Ms. Huang has researched and obtained all case files related to this particular case. There's no additional materials or attachments or graphics that's been submitted even since the last hearing here. Everything we have in terms of graphics, design improvements are all in the file. During the last commission hearing, the Planning Commission reviewed the latest design improvements and changes, and those are in the case file attached with the case motion, the case summary. So everything we have relating to the actual case is in all the case files. There's no more materials that we can produce. There's no other material. So it'd be helpful for us to understand exactly what is it that Ms. Ringo is looking for. Because if you're talking about emails, like I said, Ms. Huang is working with DT, and hopefully we can produce something in terms of emails. But in terms of actual documents, these cases, everything is in the case files.
Okay, I'm wondering, when did, I know that the original request was made many months ago. When did Mr. Ringel actually receive all of these case files?
I will defer to Ms. Huang on the exact timeline and date of the materials that we submitted, but we received multiple requests for public review of all the case files all the time for all the cases. We typically will always make them available. So when we made the case files available, the case files contain all the information we have and materials we have at that time. So there may be different stages when the case file is being requested for review, and there may be some different stages of design development and things like that. In this particular case, there hasn't been anything new since the Planning Commission hearing. The design was finalized at the hearing in the package that was submitted to the Planning Commission, provided to the public, posted online, mailed to the public. There's no additional information, materials, but...
Okay, I guess I fall in between my two colleagues here. I would like for, I realize that, we're right up against some deadlines, and it's regrettable for the complainant, and I don't think there's anything that can be done in the next 24 hours to help him, but I would like to see, nonetheless, I would like to see him continue to work with Ms. Wong about getting what is available from the backup emails. I mean, this is important for anything you might do going forward, but it's also will comply with our order of determination, and it's an important issue. I mean, bigger than this case. So I'd like to see this go back to the full task force in 2 weeks. We don't have to, at this point, make a recommendation for what's to happen at that point. It all depends on what happens in the next couple of weeks. If you're able to work with Mr. Ringel and provide everything that you can in the spirit of what he's asking for. And I think you understand what he's asking for. I mean, this is complicated. I've learned a lot today. But, like I said earlier, the law, or the ordinance, the California Public Records Act, virtually everything is public, and we don't have anything at all here that can't be disclosed. Now, the question is, do these things exist? Well, if they exist, they need to be produced. They don't need to be part of the admin record. That's a whole different thing. The admin record is probably just fine. And we don't have anything to say about that. But we do have lots to say about, every other piece of information, whatever form it's in. So if someone would like to make a motion to send this back, that would be great. Member Nee.
Yes, Madam Chair, I move to refer this back to the full task force. For consideration at that time of whether to refer this matter to the Ethics Commission.
Can we just make a motion to refer it back to the full task force without the ethics recommendation? Because by that time, if something, okay, then I'm not in favor of that right now until we kind of take it back to the full task force.
Well, we can't discuss it unless there's a second.
I'll second it.
Okay. What I said is consideration of referring to the Ethics Commission. If we don't have that in the motion, then that further delays us, because if we just say, send this back to the full task force without recommendation, then if we want at that time to vote on whether to refer to ethics, we can't, because it's not part of what we're doing now. It won't be on the agenda of the full task force. What I am saying is consideration of sending to ethics. Okay, so if we send it to back to the task force, and we hear at that time that the complainant's requests have been satisfied or are close to being satisfied, we don't have to do anything. On the other hand, if we hear that the complainant is not receiving satisfaction, then we can make that consideration on whether to send to ethics. That's the intent of my motion.
Okay. Yeah, and we can make consideration of sending it whatever we decide to do at that time, so it doesn't have to go to ethics.
All right, yeah.
Yeah, that's always want to be
That's
clear.
actually usually the case. I mean,
Yeah.
we don't, we just make recommendations here.
Yeah.
Here we're asked consideration, so it's even less straightforward. So this is the motion. Is there any public comment on the motion? Public
can't.
complainants and respondents can. Any?
David Propel again. Just to say very briefly, I think if the intent is to try to resolve this to the extent possible, I think the more direction that's given to the planning department and the complainant to clarify what it is that is being sought, the better, so that they can attempt to meet and reconcile their differences. That would be, I think, most desirable. If there still is stuff that he doesn't have or that he wasn't given that exists, they should try to identify that and give him the stuff. And if he gets the stuff, then we're good, and maybe there's no need for us to take further action. It sounds like that would be the best outcome. So let's ensure that when people leave here, they've got enough direction to try to make that happen. Thank you.
Right, okay, well, Mr. Pilpel, you know a lot about all this type of information and the laws regarding them, so perhaps you could be helpful here in helping the parties identify what is requested and how that might be obtained.
It sounds like there are paper case files, there are electronic documents, some of which were printed out and put in the paper case files, and there are some body of emails, some of which may still exist and some may have been deleted. If the department can identify everything within that universe of stuff related to that particular case number and/or that particular address, anything within that universe that hasn't been disclosed, that is subject to public disclosure and isn't attorney-client, should be disclosed to the complainant. If they can sort that out in the next couple of weeks, that would be best. I don't know if there is stuff in that universe that hasn't been disclosed. I have no knowledge about that, but that seems reasonable. Seems eminently reasonable.
I agree, yeah.
If planning needs any further clarification, let's get that out right now and try to sort it out. Just here to help. Thanks.
Okay. Is there any additional public comment? Okay, we can vote on this motion and then we can talk about, or I'm not sure that we need to have this public discussion about this. I remember Mr. Pilpel explained that all the various universes, parallel universes of information, and virtually all of it needs to be produced if it's available. Unless it's attorney-client privilege, I don't hear that as an issue here. Or any contracts, drafts of contracts, there's personnel, none of that. It's just, anything relevant to this project that's available should be produced. So that's what we're wanting to have happen, so we hear back in a couple weeks' time that we're fine.
As somebody who spent all week in the law library, now having to learn how to write a writ of mandate.
Mr. Ringel, please be seated.
Oh, I'm sorry.
You were not recognized by the chair. Please be seated.
I'm sorry.
Okay, at this time, I would like to have a roll call on the motion before us.
On that motion, Member Nee. Aye. Nee, aye. Member Grant.
Aye.
Grant, aye. Chair Washburn.
Aye.
Washburn, aye. The vote is 3-0. Motion passes.
Okay. So I would hope that the parties will now confer about how to go about resolving this. And Mr. Young, would you call the next item on the agenda?
Item number 5, administrative.
Item number 4.
Actually, thank you. Item number 4, public comment. Members of the public may address the Compliance and Amendments Committee on matters that are within the Sunshine Ordinance Task Force jurisdiction but not on today's agenda.
Is there anyone here for public comment?
Hi, Lee Fisher, Vice Chair of the Sunshine Ordinance Task Force. I just wanted to see what it looked like on this end of the podium. Now, I want to thank all three of you for the work you're doing here on this committee, and that is all.
Thank you. Is there any additional public comment?
David
Mr.
Pilpel
Pilpel?
again. I just wanted to actually mention on a moment of sadness a great loss for the city and for those of us who knew the individual. There was a statement the mayor issued earlier today. Anita Sanchez, who is the executive officer of the Civil Service Commission until her somewhat early retirement last year, passed away last night. She was a wonderful individual, a strong representative of the Filipino community, and just a very warm individual and a big proponent of the public interest and the ability of all of us to try to get along and to work to a better city. I'm very moved and saddened by her loss, and it's, in my view, a great loss for the city and, again, for those of us who knew her. So I just wanted to mention that on the record. Thanks.
Thank you. Is there any additional public comment at this time? Okay, seeing none, Mr. Young, would you call the next item on the agenda?
Item number 5, Administrator's Report.
Okay, so we have one pending case. So far, this was continued. It was originally on this agenda, but was continued, the request of the complainant. Manette Shaw Rivera versus the Public Health Commission. Okay. Is there any public comment on the administrator's report? Okay, seeing none. Mr. Young, would you call item number 6?
Item number 6, announcements, comments, questions, and future agenda items.
Members? Okay. Do I hear a motion to adjourn this meeting?
So moved.
Seconded.
Without objection. Have a nice Thanksgiving, everyone.
That's right.
Everyone.
That's right.